I'm Roxanne Groff. I'm a resident of Athens County, and I'm also a Bern Township trustee in the township in which I live. And I thank you for having the opportunity to testify at this tribunal today. I chose to address how the state and federal agencies treat citizens when we are invited to participate in mandated public participation processes. Specifically with the Department of Natural Resources and their application for a permit for a Class 2 well, and how the Bureau of Land Management and U.S. Forest Service operate their public participation processes for the leasing of public lands for the purpose of extraction of oil and gas. Both of these processes are involved with high volume, high pressure, slick water fracturing. Both public participation processes or participation methods are flawed, abusive, and dismissive, and they violate the public trust. As a consequence of the methods used by our state and federal agencies to marginalize citizens in a public participation process, we, as citizens, used our own creative and spirited responses to this treatment. We successfully staged rallies, protests. We were removed from meetings when using our voices to tell the truth. We've been arrested and encouraged hundreds and even thousands of people to protest the development of industrial horizontal fracking in our state. So in Ohio, the Department of Natural Resources has sole authority for the placement, the permitting of all disposal wells and drilled wells. One of the abuses that were put upon communities that were committed by the state legislature in 2004 was when the state legislature passed House Bill 278, when signed into law, taking all authority for regulating permitting and location of oil and gas wells away from local governments. Communities with zoning and other land use ordinances were no longer allowed to protect their citizens from drilling operations or disposal sites. Ohio lawmakers repeatedly violate the public trust by giving all power of decision-making on applications of drilling of gas wells and waste injection wells and violations of those operations to one person within the department with the title of Chief of the Division of Oil and Gas. In turn, the chief promotes the oil and gas industry. So the state of Ohio is mandated to include the public in to participate in the application process for a permit for an injection well. And the first thing, one of the things that they are required to do by law is put in the paper of local circulation an advertisement saying that a permit application has been submitted to ODNR. Well, in Athens County, the people of Torch, where one of the applications for injection wells were going to take place or wanted to be located, the people of Torch in Troy Township don't read the Athens Messenger. So not one person in the community of Torch had any idea until the wells were permitted and drilled and operational of what in the world had just showed up in their community. So now there are 3 injection wells in very close proximity to Torch. These failures to give adequate and proper notice violates human rights by denying to citizens the rights to participate in decision-making on important and vital environmental issues. Then, when people who did find the notice of publication, who did participate in the public process, scores, probably 100 letters were sent to the chief of the Division of Oil and Gas and the director of ODNR, calling for public hearings. Under Ohio law, under the Ohio Administrative Code, the kinds of comments that were received by the chief were exactly the types of comments for which the chief shall call for a public hearing. However, the chief has discretion to determine if the comments meet the requirements of substantive, relative, valid concerns for conservation and safety. If he doesn't think that the comments meet those requirements, he does not call for a public hearing. This is an extraordinary abuse of discretion, as the chief has never called for a public hearing in any Class 2 injection well application anywhere in the state of Ohio. The obligation to facilitate public participation includes obligations to safeguard the rights of freedom of expression and association against threats, harassment, and violence. The chief, ODNR, and through statutes that are passed, the Ohio General Assembly repeatedly violate these vital human rights. I'm just going to go ahead and move right on to the Bureau of Land Management and skip all this other stuff. So, turning to the Bureau of Land Management and the Forest Service, the federal government is just as guilty and negligent to the public when reviewing the environmental impacts of leasing minerals on public lands. There is a federal law in place, the National Environment Policy Act, NEPA, signed into law in 1970, which all federal agencies must follow. NEPA was enacted, quote, to declare a national policy which will encourage productive and enjoyable harmony, I choke when I get to that part, between man and his environment, to promote efforts which will prevent or eliminate damage to the environment and biosphere and stimulate the health and welfare of man, to enrich the understanding of ecological systems and natural resources important to the nation, and to establish a council of governments. There's a very specific process, again, that the federal government is supposed to use under NEPA by the Bureau of Land Management and the Forest Service for public participation. The BLM and the Forest Service are supposed to work together to ensure that the public is involved in every step of the planning process. There's a notice of intent, a scoping or public meeting, a draft plan, an environmental review, and I'm just going to move right down to the end here. So again, the federal government, the Bureau of Land Management puts in place a notice to the public comes to what they think is going to be a public meeting. It's 100 to 200 people milling around in a room. Nobody gets questions answered that are meaningful. There's no exchange of dialogue that people can hear, no chance to even know who you're supposed to direct a question to. So again, both agencies have denied the opportunity to an actual public hearing when asked by hundreds of people and even local government officials. So the thousands of comments were submitted to the Bureau of Land Management from concerned citizens asking for a public hearing and an environmental impact statement, which is the mandated method of review for environmental impacts and public harm. There was no consideration given to the impacts of environment, socioeconomic, historical, and cultural impacts, or the cumulative effects of methane emissions known to accelerate global climate change. The public was manipulated, misled, and even lied to by federal agents of both the Forest Service and the Bureau of Land Management. These are deplorable actions by federal agencies resulting in abuses of human rights, nullifying the intent of NEPA, which requires that the public participation be facilitated. The Bureau of Land Management and the Forest Service have stonewalled the public in this battle for the rights of citizens as human beings to be safeguarded, to be guaranteed a safe environment. And I want to read from the preamble of the Declaration of Human Rights. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. And how dare our federal and state governments make us fight for our lives and, more importantly, the lives of our children and future generations on our own soil. Thank you. I will entertain questions.
You mentioned a public meeting where the people didn't know who to talk to, or where was that held?
There are three of them. This is one of the egregious errors that the state and federal government commit. On the federal government side, for looking at the leasing of public lands, 3 meetings were held in each of the forest districts, one in Marietta, one in Athens, and one in Ironton. And by having a meeting in the largest city in the forest district, it eliminates the possibility of people from rural areas being able to come in, you know, drive sometimes, you know, maybe 50, 75, 150 miles to come to a meeting, which of course it violates the Environmental Justice Act of not discriminating against people. And where people think they're going to be coming into a meeting situation where they can exchange meaningful dialogue with someone, you walk in, there's 200 people in the room, it's noisy, it's you have no idea who anybody is, there's just a group of, you know, Forest Service people with easels and charts and pieces of paper, and nobody can hear anybody speak. So they did that 3 times. Instead of a hearing, they conducted just a public meeting.
And what would be the difference if they had had a public hearing?
Well, a public hearing is it's set up just like we're doing, where there's the panel of Forest Service employees, it's recorded, documented, it's on the record, testimony is submitted as evidence, people have a chance to listen to what other people are saying, people can testify on what it is that they know, and ask what they don't know. So it's very, very different, and it's purposeful on the part of the government to not do that.
And can that be reviewed in court, that public hearing, in a court of law?
I mean, could the evidence from it?
Can the public hearing, can the testimony and the evidence be reviewed in a public court? I think it can in some instances. Certainly in the state, it can be, and Mike is nodding his head back there. I think federal also. It can be reviewed in court. It gives the citizens what they have said, the
Right.
ability to be reviewed in
As
court by a
evidence.
judge instead of just by the chief of ODNR.
Right.
You know.
Right.
Thank you. Thank you.
I have one final question. You had a meeting of many people with the Wayne Forest at their headquarters. And did you get to speak with the lady who was in charge of that headquarters? And she eventually turned your request down. Do you know anything about that process, who she talked to from up above?
Well, I had 4 meetings myself with Tony Scardina, who's the supervisor of the Wayne National Forest, and I had arranged to have a phone meeting with Kathleen Atkinson, who is the regional forester of Region 9 in Milwaukee, and had set it up. We were all prepared to speak on the phone, and she canceled the meeting and then never communicated with me ever again.
Thank you.